We'd like if people could take their seats so we could get started. So we just heard a panel talking about the successes and challenges the EPA has dealt with in implementing the Clean Air Act, which is certainly one of our most important and significant environmental statutes, one of the most important statutes that the Environmental Protection Agency administers. Now we're going to have the opportunity to hear from the person responsible for seeing that that law is implemented and enforced, EPA Administrator Andrew Wheeler. As an initial matter, I just wanted to make a comment. As some of you may know, this morning we had some protesters out front, which is awesome, not because it shows that people care about these issues and are interested in these issues and are interested in an exchange of views. I will remind folks that under the university's free speech policy, although members of the university community are free to criticize and contest the views expressed on campus and to criticize and contest speakers who are invited to express their views on campus, they may not obstruct or otherwise interfere with the freedom of others to express views they find to be wrongheaded or objectionable. That was probably unnecessary to remind anybody of, but I felt it was worth doing. I want to introduce Administrator Wheeler. And then after his remarks, we will be taking questions. Students will be passing out note cards for individuals who would like to ask questions. So just write your question on a note card. They'll be passed up to me, and we will have some good back and forth. But it's really my pleasure to be able to introduce the nation's 15th Administrator of the Environmental Protection Agency, not least because he got his undergraduate degree here at Case Western, where he studied English and biology. After that, he got his law degree at Washington University in St. Louis, his MBA at George Mason University. He worked in Congress as staff director and chief counsel on the Senate Committee of Environment and Public Works, has worked in consulting and lobbying, and worked as a special assistant in the EPA's Pollution Prevention and Toxics Office. He was initially appointed to be Deputy Administrator of EPA, and then was more recently confirmed, as I mentioned, to be the 15th Administrator of the EPA. You've all heard me talk more than enough so far this morning, so without any further ado, I'm going to turn the podium over to Andrew Wheeler.
Good morning. It's a pleasure to be with you today. I want to thank you, Professor Adler, Jonathan, for the introduction. We've actually known each other at least 20 years, something like that. And I want to thank the university for hosting today's important forum. It's great to be back at Case Western. As Jonathan said, I graduated undergraduate here, 1987. I almost attended law school here. It came down to the wire between Case Western and Washington University. Do we have any faculty who were here in the 1980s? Nobody? Okay. So you will understand what I'm about to say. One of the final decisions between attending Case Western Law School and Washington University was right when I was making the final decision, my car was stolen for the second time outside of the dorm. The campus has changed a lot since the 1980s. It's a lot safer, and when it was stolen for the second time, I just said, I want to try a different city for a while. So I went to Washington University in St. Louis. I know I would have had a great experience here if I'd stayed at Case Western. Next year, as you all know, the purpose of this conference today, EPA turns 50. To borrow from the old Henny Youngman joke, you know you're 50 when you're warned to slow down by your doctor instead of the police. My speechwriter, Chris Beach in the back, wrote that line for me. He's about half my age. I think he thinks that Henny Youngman was a comedian when I was young. I'm picking on him because today is actually his last day with me. He's going over to the Department of Defense after today, and he's done a great job for me over the last year and a half. Thank you, Chris. Yes, please. The agency has matured, but we're not slowing down anytime soon. We have a lot of important work to do. For my remarks today, I'd like to focus on two EPAs, the EPA of the last 49 years and the EPA of the next 50 years. I don't think there's any question that our nation has made tremendous environmental progress over the last 49 years. From 1970 to
Climate
2018.
change are already upon us. Andrew Miller's pro-extraction policies have no place at the EPA or in this room. Citizens of conscience cannot stand idly by while men like him are awarded power and privilege for destructive policies.
The combined emissions of the main 6 air pollutants dropped 74%, while the U.S. economy grew by 275%. Emissions of all 6 of the criteria air pollutants have continued to decline under President Trump. In the 1970s, more than 40% of our nation's drinking water systems failed to meet even the most basic health standards. Today, over 92% of community water systems meet all health-based standards all the time. That's not to say that the other 8% fail to meet them all the time. They may have a day here or there, but we work with those communities. But it's an incredible improvement to go from 40% in noncompliance to less than 8% in noncompliance today. Today, we have the cleanest air on record, and we are ranked #1 in the world for access to clean drinking water. My point here is not to gloss over our challenges, but to demonstrate that the efforts started in the 1970s to clean up our air, land, and water have largely been effective. We all know that there is still much work to be done. We face significant challenges, some that have plagued the agency for 49 years. But to properly understand and address these challenges, we must go back to our founding. EPA is the child of a large executive branch reorganization. President Nixon transferred 15 existing units from 4 government agencies into the new independent agency. Air, solid waste, radiological health, water hygiene, and pesticide tolerance were transferred from the Department of Health, Education, and Welfare. Water quality and pesticide label review came from the Interior Department. Radiation protection standards came from the Atomic Energy Commission and the Federal Radiation Council. And pesticide registration came from the Department of Agriculture. All these incoming employees had to learn new policies and protocols, not to mention keeping pace with the slew of new environmental laws passed in the 1970s. One result of piecing the agency together in this fashion is that we have tended to be very siloed mentally, and that has continued throughout the last 49 years. The Air Office operates in its silo, the Water Office in its silo, and so forth. That's a mentality that we've struggled with for the past 49 years, and it impacts our rulemakings and how we interact with the states and the regulated community. We have to break down those silos, and that's what we've been working on. I think our best effort in this regard has been on the PFAS Action Plan. The action plan is the first time that we utilized every single one of our program offices to put together a multimedia national research and risk communication plan to address an emerging chemical of concern that had never happened in the 49 years of the agency. We issued that plan this past February, and we are looking at all of our statutes, and we're moving forward to protect the public from PFAS. Does everybody know what PFAS is? It's a chemical that was in Teflon, Gore-Tex, Scotchgard, firefighting foam. It's ubiquitous in the environment as well as in commerce. It gets into the drinking water, and it's an incredibly difficult environmental issue to grapple with. And we are using all of our statutes to try to address it. And it bioaccumulates. It has an impact on internal organs, kidneys, and livers in people. It gets into the water system, and there's over 5,000 different PFAS chemical substances. 602 have been in commerce in the last 10 years in the United States. 1,200 overall have been approved in commerce in the United States over the last 10 to 20 years. And it's hard to detect. You can't use the same detection method for all the PFAS chemicals, and you can't use the same cleanup technologies for all of them. We're moving forward with the process to develop a national drinking water standard for PFOA and PFOS, and we've begun the regulatory development process for listing PFOA and PFAS as hazardous substances under the Superfund statute. And in April, we released for public review and comment the interim groundwater cleanup recommendations for sites contaminated with PFOA and PFOS. All of these actions required coordination across program offices, and I'm very proud of the progress that we're making in this respect. While the agency has been slow to change in some respects, in other respects, certain changes have been an important and necessary part of the agency's development. 40 to 50 years ago, EPA was the primary enforcer of our nation's environmental laws. The Clean Water Act, the Clean Air Act, and our other core environmental laws always envisioned a major role for the states, but it took states time to build up their programs. And early on, EPA had to throw its weight around to prove its authorities were legitimate. Here's what William Ruckelshaus, the first EPA administrator, said during his confirmation hearing. Quote, "As far as I view the mission of this agency, and my mission as its proposed administrator is to be as forceful as the laws that Congress has provided and to present firm support for enforcement by the states." And he meant what he said. In its first year alone, EPA referred 152 pollution-related cases to the Department of Justice for prosecution. And only a week after becoming the first administrator, Ruckelshaus announced that EPA was serving the cities of Atlanta, Detroit, and Cleveland with 180-day notices that directed them to stop violating federally sponsored state water quality standards. In response, Cleveland Mayor Carl Stokes accused Ruckelshaus of making a politically motivated assault on Democrat-controlled cities. Sounds vaguely familiar to the response of a certain state out west to some of our recent actions. Contrary to what some may think, our actions are not unprecedented. EPA has been doing this since week one of its existence, and in many cases, we are acting where other administrations have failed to. For the past decade, New York City has failed to comply with the Safe Drinking Water Act requirements that keeps its drinking water safe from harmful bacteria and viruses, even when it was under an order to do so. In March of this year, we compelled the city to comply by covering and protecting its Hillview water reservoir. Implementing the consent decree will cost the city almost $3 billion. It's costly, but New York City is not exempt from the law. No state or city is exempt from the law. The difference today is that over time, states have assumed their delegable authorities under federal law. In fact, states have assumed 96% of those authorities. We have delegated the Clean Air Act permitting program to 48 states. We've authorized the Clean Water Act permitting program in 47 states. And we've authorized 49 states to act as a primary enforcement authority under the Safe Drinking Water Act. In most cases, the states are now the front line for enforcement and inspection. Federal enforcement is now a smaller part of assuring compliance with environmental laws. 40 to 50 years ago, we did it all. Now the states play a major role, and we need to recognize that change. Much of our enforcement role today has transitioned to ensuring states uphold their obligations while also working with them to handle very complex enforcement cases. Case in point, in January of this year, EPA and the Department of Justice announced a $490 million settlement with Fiat Chrysler for cheating on U.S. emission standards. For 3 years, Fiat Chrysler told us that their vehicles were compliant, yet it was EPA engineers in our Ann Arbor lab that caught them cheating. Then they proved how they were cheating. We had to prove how they were cheating, and that was no easy task. The defeat devices were hidden in vehicle software that can have more than 100 million lines of code. To give you an idea of what the EPA staff had to deal with, an F-22 fighter jet has less than 2 million lines of code, and a Boeing 787 has around 14 million lines of code. Of course, this is not the first time that a vehicle manufacturer has purposefully installed hidden software that defeats emission controls. Volkswagen installed similar defeat devices in over 500,000 vehicles. These examples illustrate how we see our role moving forward over the next 50 years, taking on these large, complex cases that the states don't have the authority, they have the authority, but they don't have the resources in order to take these cases on. To do this successfully will require us to work more closely with the states, which has been a primary objective of our administration. In Ann Gorsuch's memoir about her time at EPA, she writes that the Reagan administration inherited a backlog of nearly 2,000 state implementation plans. These are the plans under the Clean Air Act that the states submit to comply with the air quality standards. Reading her memoir this past year, I couldn't help but notice the similarities with our current administration. We inherited a backlog of over 700 SIPs from the previous administration. Since the fall of 2017, we have redesignated 19 areas around the country, moving them into attainment with the National Ambient Air Quality Standards and lifting major regulatory burdens off local businesses. To give you an idea of our change in approach, the previous administration imposed more than 50 federal implementation plans, or FIPS, on the states. and that's about 10 times the number of FIPS imposed by the 3 previous administrations combined. We are working hard to convert those FIPS back to SIPs, working cooperatively with the states. We have averaged almost 1 FIP to SIP per month since March of 2017. We are also aggressively tackling the backlog of SIPs that I mentioned earlier. Of the more than 700 SIPs that we inherited that were backlogged, we've taken action on over 400 of them. So we're down to less than 300 in the backlog. We're also keeping pace with the SIPs that are submitted each year by the states. For EPA to be successful over the next 50 years, we must work closely with our state and local partners. This is one of the reasons we realigned our regional offices with headquarters. Our regions are often the first line of interaction with the agency. It didn't make sense to have an air office at headquarters, but not in the regional offices. We actually had 2 regions that did not have an air office by title on their organizational chart. So we realigned our regional offices, and we've mirrored our regional offices with headquarters. And now we have a much more integrated and streamlined line of communication from the local level all the way up to Washington. In each of the examples I've mentioned, it's easy to see that we're asking a lot of our staff, and we expect a lot of them. One reason is that we know how talented and dedicated our staff is. The other reason is necessity. At its peak, the agency had over 18,000 full-time employees in 1999. Under Presidents Clinton and George W. Bush, the agency consistently hovered around 17,000. Today, we're down to 14,000. We must act and plan as if we will not reach the previous levels again. This also requires us to recognize that the broader workplace culture in America is shifting. 50 years ago, people went to work for one employer, and it was not uncommon for them to work most of their lives at that place. In fact, today we still have 10 charter employees that have been with the EPA 49 years. We can't expect that anymore. In fact, right now, 40% of our workforce is eligible to retire over the next 5 years. Millennials, and I know there's some in the audience today, are a different generation. They expect to work multiple jobs throughout their life. We need to adapt to that as an agency, and we need to do a better job attracting and retaining good talent. We hired a new human resources director. We'd had an acting resource director for years. We hired a new permanent one in March of this year. I actually interviewed the human resources director. I was told that that was unusual, that the human resources director is 3 or 4 levels below me, and administrators don't typically interview people at that level. But I said I have a dozen issues I'm going to hit her with on her first day. I want to make sure that she understands where I'm coming from. We need to do a better job of attracting people. In the past, managers at EPA would hire somebody, train them, and expect that they would be in the job for 30 years, 40 years. We can't expect that anymore. We also have to do a better job as people retire, making sure that we don't lose that historical knowledge as people leave. When I visit all 10 of our regional offices, I do all hands meetings, and I take questions from the employees everywhere I go. I was in Region 7 in Kansas City, and one of the human resources employees said that she had developed a database. As people retired, they would enter all the information that they had to pass on to the people that would replace them. She went away on a detail for 2 years, came back, and the region had redesigned their computer systems, and her database had been wiped out. I told our human resources director, we need something like that across the entire agency. As we start to lose this 40% of our employees who are eligible to retire, we need to make sure that we're not losing the historical knowledge that they have. This is so important to the mission of our agency. When the talent leaves, we need to ensure that the knowledge is preserved and passed along. We're also taking initiatives to develop creative ways to attract and retain top talent. In order to implement our updated TSCA law, which passed in 2016, which is more efficiently performs risk assessments, we have been focused on recruiting highly trained scientists. One of the problems that we had, we focused our human resources last year on trying to hire new risk assessment scientists to the agency for the TSCA program. We put a lot of resources. It takes a long time to hire a federal employee. Our goal from start to finish is 90 days, which is fairly long, nothing like in the private sector, and that's if we're moving quickly. So we put a lot of resources in 2018 to hire new risk assessors. We were able to hire 30 new risk assessors for the TSCA program, which is an incredible achievement from the Human Resources Department. At the same time, 30 researchers retired from that program in 2018. So we put a lot of time and resources in, and we're barely treading water on trying to get new talent in. One of the things that we are looking at now is perhaps opening a risk assessment office down in our Research Triangle Park office, because of so many research universities in North Carolina, and people who graduate from those programs want to stay in that area. So we're trying to be creative on where we place our scientists to make sure that we can attract and retain as many quality scientists as we can. As any large organization knows, when you have ample staff, you don't have to be as efficient. We, on the other hand, are learning to do more with less, and we need to be more efficient. We found that out very quickly. Prior to this administration, the agency was not tracking some of its most important obligations. For example, beginning of this administration, President Trump announced he wanted all federal permits to be done within 2 years. My predecessor set a goal for EPA for permits to be done within 6 months. We quickly discovered that the agency was not tracking how long it took to issue a permit. You cannot improve a process if you do not track how long a process takes. So we implemented the lean management system across the entire agency. Now, this actually was launched by Gina McCarthy, the last administrator in the Obama administration, and she launched lean management as a pilot program in a few offices at the agency. Lean management, bless you, is also called the Toyota system, the Toyota management system. When I worked at EPA, my first job out of law school was at EPA back in '91. We tried to introduce total quality management, TQM, to the agency. It didn't really work or take off. TQM is a bottom-up approach. Lean management is both bottom-up and top-down at the same time. We've had tremendous success so far on the lean management system. On the permit side, we've reduced our backlog of permits over the last year by 54%. We also have our large enforcement laboratory in Lakewood, Colorado. They do the large multimedia enforcement inspections all around the country. It was taking them on average over 180 days to issue an inspection report. We implemented lean management system there last year, and now over 90% of those inspection reports are issued within 30 days, which is incredible if you think about it. That was 180 days where the facility didn't know what was going on or if they were doing anything wrong, but it's also 180 days where no environmental improvements were taking place because we weren't issuing the inspection reports to the facilities. I know that I'm running short on time, but I do want to highlight a little bit on Superfund and brownfields, and how we're prioritizing the mission of the agency. We can't be everywhere at all times, and that's not how Congress envisioned our role. But we do have some very important fundamental responsibilities that the agency has not consistently upheld throughout its 49-year history. A prime example would be the Superfund program. And I think it's fair to say that the agency did not anticipate the magnitude of the challenges it would take on when the Superfund program was created. The crisis at Love Canal awakened the nation to the reality of the problem, but it soon became clear that RCRA and the Clean Water Act were not enough to address the problem. So in 1980, CERCLA was passed and the Superfund program was created. By 1983, preliminary assessments were conducted at 7,300 of the 17,000 sites already identified, and 546 were placed on the MPL list. It wasn't too long before the MPL list grew to over 1,000. Most of these sites are incredibly complex and require a lot of time and financial resources. Thus, it wasn't unusual for a site to sit on the Superfund National Priorities list for decades. Perfect example is the Westlake landfill in Missouri, home to radioactive waste from the Manhattan Project, which has been on the MPL list for 2 decades. We believe that the agency must do better, and we believe that a site on the national priorities list should be just that, a national priority, and our actions demonstrate that. This past year, we reached an agreement with all the PRPs and the local residents around the Westlake landfill, and we're moving forward on getting that cleaned up for the first time in over 2 decades. In fiscal year 2018, EPA deleted all or part of 22 sites from the MPL list, the largest number of deletions in 1 year since 2005. And I'm very pleased to report that in fiscal year 2019, EPA removed all or part of 27 sites from the MPL list, the largest number of deletions since 2001. This is an exceptional and important achievement carried out by the EPA career staff. And these accomplishments are the result of detailed plans to refocus and re-energize the Superfund program. We launched the Superfund Task Force and created the Administrator's Emphasis List to help get sites on the edge of completion across the finish line. Our success in the Superfund program exemplifies the tremendous potential of the agency. More often than not, the residents living near Superfund sites are low-income or underserved communities. Our work is breathing new life into these communities and transforming frustration and despair into hope and opportunity. This, in short, is our vision for the EPA's next 50 years. An agency that is agile and responsive to the needs of the public, an agency that works seamlessly with its state and local partners, an agency that attracts and retains world-class talent that reflects the diverse society that we serve, and an agency that is a global leader in science and research. Of course, these goals will soon slip out of my control. I may have a say over the next 5 years, but not the next 50 years, which is why we're implementing things like the lean management system. In fact, what we did this year, the Senior Executive Service, the most senior career officials at the agency, we put it into their performance evaluation system. So one of the measures that they are judged on today is implementing a lean management project or program within their offices. We believe things like this and the reorganization of our regional offices and the hiring and then trying to cut across our silos to produce more comprehensive management plans for environmental issues where we don't look at things just in the clean air silo or just the clean water silo, but across the board using all of our offices will make the EPA a much more nimble organization that will protect the environment and public health of Americans for the next 50 years. Thank you all for your time and your attention. I appreciate that and happy to answer some questions.
So if people have questions, they filled out on cards, please give them to the students that are collecting them. I believe, for those of you in the overflow room, I believe there should be a student collecting cards there as well. So when you were first asked to serve in this administration, you were asked to be deputy administrator, and your predecessor was controversial as administrator, and many people have commented that there are significant stylistic and managerial differences between the way you operate the agency and the way your predecessor was. And I'm just wondering, is that conscious? Is there a way you would describe how the agency is being run differently now than it was, say, in 2017?
You know, I think you can say that about any two administrators in the history of our agency. You know, I'm just the 15th administrator, and I don't think any of the 15 administrators, my predecessors, none of us have been alike with each other. We've all had different management styles. We've all taken different approaches. You know, Scott came to the job. He had never worked in D.C. before. I've spent my whole career in D.C. You know, I started my career at EPA. I was a career employee. I think that has helped me a lot, understanding how the agency works, the mission of the agency. When I graduated from law school, I went to work at EPA because I believe in the mission of our agency. And I spent 14 years working on Capitol Hill, you know, as the authorizing staff director for the committee that oversees all but the pesticides program at EPA. So I had a lot of experience there for 14 years, and then I worked in the private sector for 9 years. So I had a lot of different experiences that I think has really helped me lead the agency as we go forward into the 50th anniversary.
One area that the agency appears to have had some trouble with in the last 3 years is in court. A bunch of early initiatives have been struck down by various courts. Was that due to something the agency was doing? Is that something a result of something the courts are doing? As administrator of the agency, and as someone who I assume wants to have your regulatory initiatives upheld and implemented, what is your perspective on the EPA's track record in legal challenges?
You know, some of those defeats, some of the defeats, like on the coal combustion residual, were Obama regulations where we were defeated. We certainly lost a few in the first year. That was before I joined the agency, as far as freezing some of the regulations and the deregulatory efforts. But under under my watch, what I've told our attorneys, what I've told our program offices, is that I want to make sure that what we're doing will stand up in court, which is our approach on ACE. We followed the Clean Air Act. We followed the Supreme Court cases. I think it's, considering the Clean Power Plan was stayed by the Supreme Court, I think our final ACE rule will be upheld by the courts. We had the same approach for WOTUS. As soon as the previous administration's WOTUS was issued, it was 27 states sued, and it's never fully taken effect. Our WOTUS proposal, I believe, follows not just the Clean Water Act, but also the Supreme Court cases there. So what I've told my staff is that I want to make sure that our regulations will stand the test of time and will be upheld by the courts. And I've probably been a little more lax on deadlines, internal deadlines, than my predecessor was. He wanted to get things out the door and meet internal deadlines. I've given our teams more time to make sure that we're getting the law right and making sure that the regulations will stand up in court.
One of the actions EPA has recently taken was rescinding the so-called appropriate necessary determination. That is the basis for the mercury and air toxic standard, or what those of us that work in this field refer to as the MATS standard. In the revised proposal, the agency excludes what we often refer to as co-benefits, or the ancillary pollution reduction benefits, that if you're doing something to reduce emissions of one pollutant, the benefits of other pollutant reductions that tend to coincide with or occur with. Can you say something about why the agency has decided that these sorts of co-benefits or ancillary benefits should not be part of the evaluation in determining whether it's appropriate and necessary to adopt the standard? And does this reflect a broader view within the agency that ancillary benefits should not be part of the way that regulatory proposals are assessed?
We will still look at co-benefits going forward, but when you look at the mercury air toxics, 99% of the benefits for that regulation came from particulate matter. We already regulate particulate matter under the NAAQS program. So, I do not believe, and I think the Supreme Court was very skeptical, and we're following the Supreme Court remand. Was very skeptical about the fact that the agency was depending upon co-benefits to justify regulation instead of the substance that was being regulated, which was mercury. So I do think that's inappropriate, and you see that in our new cost-benefit regulations that we're moving forward on. We proposed in 2017 a cost-benefit regulation to apply to all of our statutes across the board. We received over 4,000 comments. We took a hard look at the comments. We decided that was not the right approach. So what I've decided to do is to move forward on a statute-by-statute basis. And we will now be proposing a cost-benefit regulation for each statute, following the guidelines and the science within the statute and the requirements. And the first one will be the Clean Air Act. And we plan to have that out before the end of this year. And after the Clean Air Act, we go through each of the statutes under our authority to implement a cost-benefit regulation. But I think that's very important to the future of the agency, and it also goes to the science integrity side, where we have to be upfront with the American public. I think there's a lot of people that were very skeptical, upset over the MATS case because it was supposed to regulate mercury, and all the benefits were from PM.
One issue that you didn't touch on in your talk, and I have a bunch of questions about, is climate change. And this administration certainly is being a lot less aggressive in seeking to regulate greenhouse gases than its predecessor. Is that because the agency does not believe climate change is a particularly significant problem? Is it because the agency does not believe the Clean Air Act provides the agency with tools necessary to deal with greenhouse gases? Is it something else?
Well, first of all, we are moving forward on greenhouse gases. Our ACE rule will get a 35% reduction from the electric power sector over the course of the regulation. Our methane regulation will reduce methane emissions, and our CAFE proposal actually will also reduce CO2 emissions. Is interesting. Yes, our proposal and our final CAFE standard is not going to look like our proposal. We're making changes to it. Can't say what the changes are today.
Can you say when they're coming out?
Before the end of the year. But you know, in our proposal, we did freeze the standards at 2022 to 2026. I think I got the years right there. But you know, it was interesting. After we came out with the proposal, the Auto Alliance came in and met with me and said, you know, do you realize that some of the out years you're actually more stringent than the Obama regulations? Because we did away with a lot of the credits that the auto companies could use in order to comply. So under the Obama standards, even though they ratcheted it down each year, because of the off-ramps and the credits that they were providing under that regulation in some of the out years, our regulation was actually more tight than their proposal was. So our final CAFE standard will be different than what we proposed. We received a lot of comments. We've already. I'm going to pick on the California and the New York AGs for a second. They have a tendency of announcing that they're suing us before they actually read our proposals. And you worked at CEI, right? Back when. It was interesting. I attended the CEI dinner this summer, and it was right after we went forward with the ACE rule. And the day before the ACE rule came out, the AG in California announced he was going to sue us. We proposed the ACE rule. Then the next day, I heard the current president of CEI say that, you know, we're not sure if we like the ACE rule or not. I'm going to reserve judgment on it. I want to read it before I make a determination. And then 2 months later, he announced he was suing us. I much prefer somebody to take 2 months and read our proposals before they announce they're going to sue us than announce they're suing us before they've actually even seen it. We're always going to be sued by both sides all the way through. And it was interesting on the ACE rule. When we did that, I got beat up on the left a lot, very vocally in public. Senators, congressmen, environmental groups saying we weren't doing enough. What we did under the ACE rule is follow the Clean Air Act and follow the Supreme Court cases. The Clean Power Plan was stayed by the Supreme Court, in my opinion, because it went outside the Clean Air Act. I also got beat up on the right. I got phone calls from members of Congress saying, why are you doing anything? You should be overturning the endangerment finding. You shouldn't be doing anything on climate change. That's not what the Supreme Court has told us to do, and that's not what I believe the Clean Air Act tells us to do. But we are extremely limited under the Clean Air Act on what we can do on CO2. Congress is, you know, John Dingell said it would be a glorious mess to regulate CO2 under the Clean Air Act, and I think he was right. It is a glorious mess. And we are doing what we believe the Clean Air Act tells us to do and what the Supreme Court has told us to do.
If it's a glorious mess to try and regulate greenhouse gases under the Clean Air Act, should Congress revise the Clean Air Act or enact new legislation that gives the EPA tools that could address climate change more effectively and efficiently?
I got you're asking me that question much more politely than Governor Inslee did when he asked me that question, and that was at a breakfast that I hosted for the Western governors at EPA headquarters last winter. He said, when I said what I said about ACE, that we're following the Clean Air Act, we're following the Supreme Court, then why aren't you telling Congress to pass new legislation? First of all, that would require going through the White House and OMB. I can't make the decision what we're asking Congress to pass as far as legislation is concerned, but I don't think this current Congress is going to pass climate legislation. I think it was interesting when the Waxman-Markey bill passed the House of Representatives and went over to the Senate, and Senator Reid had 60 Democrats. He had filibuster-proof Senate, and he didn't even bring climate change up on the Senate floor. I don't think, regardless of who is in control in the Senate, that they want to address the issue.
Later today, you're going to be meeting with undergraduates who are leaders of various student groups, and earlier this week, the undergraduate student government prepared a letter, which I think they're going to be giving you a copy of. And one of the things the letter says is, the undergraduates of your former institution are concerned that the EPA is moving in a direction counter to its purpose as the prevention of further climate change, maintenance of clean air and water, and preservation of the lands of our great country are responsibilities now under your protection. What would you say to these students, or what will you be saying to these students when you meet with them later?
I'm looking forward to meeting with them, and I'm happy to discuss this with them. I'm afraid that they're probably getting their views from the media, which is not always accurate on what we're doing. we are cleaning up brownfield sites and Superfund sites a higher priority than the last 3-4 administrations. We proposed last week new lead and copper rules for drinking water that are more stringent than currently on the books, and the first update to the lead and copper rules since 1991. A huge issue. Flint, Michigan, Newark, New Jersey today. We have to protect the drinking water systems in this country, and lead is a huge issue. PFOA and PFOS, as I said in my remarks. This has been an issue that's been out there for about 10 years. We're taking direct action on this. I will say there was an op-ed this week by my predecessors, Bill Riley and Gina McCarthy, accusing us of not doing anything on asbestos. I'm actually going to be responding to them because it sounds like neither one of them have read the new TSCA law. Because we're actually being more aggressive on asbestos than the agency has been since Bill Riley was administrator in 1989 when the agency lost the big asbestos lawsuit. We have put asbestos as one of the first 10 chemicals on the new TSCA program. We have to go through the regulatory program before we can ban or prohibit a substance. As administrator, and they both should know this, as administrator of the EPA, I cannot prejudge a regulatory outcome. If you prejudge, if I say today we're banning asbestos, and I'm not saying that, if I say we're banning asbestos, we can be sued, and that could be considered prejudicial in a legal proceeding. I cannot claim what we're going to do in a regulatory process until we've gone through the entire process. We also instituted a SNUR, a significant new use rule for asbestos. Since 1991, anybody could have imported asbestos products into this country without any regulatory oversight. By putting forward the SNUR this past spring, we now require if anybody wants to import an asbestos product, they have to come before the EPA, and that will give us the opportunity to ban that substance or prohibit or make restrictions on it while we wait for the TSCA, which is about a 2-year process to work through. So there was a huge loophole, and that loophole has been in place since 91. We're the first administration to close that loophole. And I'm being attacked in the press by not doing enough on asbestos. We're the first administration since 91 that's taken asbestos seriously. And I'm still getting beat up because first of all, whatever I do, the environmental groups are going to criticize it, no matter how good it is for the environment. It's a national game for them. But we are being more aggressive than any administration. I'm also going to be interviewed by the Observer newspaper after this. I'm looking forward to that. I actually worked on the Observer. I wrote the weekly trivia quiz on the Observer for 3.5 years when I was an undergrad here. And I did a couple of op-eds in the Observer too, and one of them was in 1987 where I called for eliminating animal testing. And what I signed this about 2 months ago was a decree to the agency that we will eliminate animal testing at EPA 30% by 2025 and 100% by 2035. I was immediately accused of doing this because of the chemical companies. I've never talked to a chemical company about animal testing at all. I'm doing this because I believe this for the last, I can't do the math, since before 1987, but I wrote this as an op-ed in the student newspaper here at Case Western in 1987 that we need to move to eliminate animal testing. I believe that as a principle. But I'm still, I even passed out copies of the Observer editorial that I wrote to the press to make sure that they understood it. I'm still getting beat up saying, oh, he must be doing this for the chemical companies. I can deal with that. I get beat up regardless, but I'm still moving forward.
Well, we appreciate your taking the time today. I want to keep you on your schedule and not keep the folks at the Observer waiting. And I know you're looking forward to meeting with the group of undergraduates at lunch and then with the Great Lakes Energy Institute fellows this afternoon. So thank you again for making the time and taking questions. And safe travels back to DC.
Thank you.